Okay. Hello, dear students. Welcome to this video lecture series on behalf of CLAT SATHEE. I am Dr. Animesh. I am here to discuss divorce under Hindu law. In the last class, as you remember, we discussed a relief, a remedy called nullity. Nullity we also discussed. Nullity primarily means declaring that a marriage never happened. That is the point of nullity. Nullity, we discussed various grounds of nullity, how nullity works, and we discussed all that. Now, divorce presupposes and it supposes that a valid marriage existed. If there is no valid marriage, there is no question of divorce. If a party questions the validity of marriage, then it can go for nullity, declaring the marriage is void. We discussed the grounds for that in the last class. I hope you remember that all. And today we are talking about dissolution or divorce under Hindu law. So, without any further delay, let's talk about its dimensions. Now, while the topic is generally dissolution or divorce under Hindu law, what we are discussing is matrimonial causes. Matrimonial causes means in a marriage, what kinds of disputes are there and how they're adjudicated. झगड़े कौन कौन से हैं और उनका निपटारा कैसे होता है. This things is very important. Now, first things first. Uh, Suppose there is a marriage. Obviously, it's a Hindu marriage. In that, how the marriage comes to an end. How a marriage comes to an end, that is a question. Now, all of you understand that there are two primary ways in which marriage comes to an end. First is obviously death of one of the parties. Death necessarily dissolves marriage. Once the death one of the party dies, the marriage ends, and the other party is free to marry again. All the all the obligations associated with marriage ends with the death of the party. And second way is dissolution. Now, dissolution of marriage happens only through court. That is something that you have to understand. In Hindu law, parties are free to solemnize the marriage. They can solemnize it as they please. Simply, if you want to get married, go to a temple, get married, and your marriage will be a valid marriage. No problem. Nothing, no issue. The law will accept that marriage as a valid marriage. But if you want to end a marriage, you cannot end it in the same way you will create it. You cannot simply go to a temple and get the marriage annulled. You cannot go and say that we want to end our marriage, so our marriage should be ended. In a like a contract, you cannot simply sign an agreement that you are dissolving the marriage amongst yourself. Even if the party make a stamp paper, write that we are going to end the marriage and we want to end the marriage will not be dissolved. A Hindu marriage can happen in a temple, can happen at a home, anywhere. It can happen at the marriage registrar's office, whatever. But once the marriage happens and the parties are now husband and wife, they cannot dissolve it in the same way. They cannot dissolve it at a whim. या हो गया, अब हमारा मन नहीं लग रहा, तो हम लोग शादी खत्म कर देते. Neither one of the party unilaterally can dissolve. Neither both of the parties, if they want, they can decide it. They can simply dissolve it on their own volition. The dissolution of a Hindu marriage happens only through court. If court is not there, there is no dissolution of marriage. An order, a decree of the court, a divorce decree from the court is must to ensure that the marriage has been dissolved. अगर कोर्ट से डिक्री नहीं है, कोर्ट से आदेश नहीं है, तो आप कितना भी आप अलग if the parties are living together apart for 20 years, 30 years, 40 years, still they will be considered marriage. Even they might not have lived together at any point of time. But if they have lived, if they got married, they will remain married for all times to come. For eternity, they will be married. Till a court dissolves it or it is dissolved by death of the one of the party. जैसे 7 जन्मों का साथ तो नहीं रह गया marriage. Death dissolves the marriage, but nonetheless, either death dissolves it, court dissolves it. The parties themselves cannot dissolve it. A priest cannot dissolve it. A religious body cannot dissolve it. A panchayat cannot dissolve it. Even if the government writes it is dissolved, it is not dissolved unless there is a decree of court. That has to be very much understood. Okay. But whether courts are keen on dissolving it, the answer is no. If you will read Family Courts Act, it says that the court, whenever a matrimonial dispute comes, they should always attempt for reconciliation. They should always try and attempt reconciliation. That is a solemn duty of the judicial officer. Whosoever is the judge, if a party comes say कि सर हमें divorce चाहिए, हमको नहीं रहना, हमारा झगड़ा है, the first thing that the court will do will refer them to mediation. You go and try and you get a mediator, court provides a mediator, and with the help of that mediator, you try to resolve your dispute. मीडिएटर के साथ बैठिए, प्रयास करिए डिसॉल्व करने का. Try and resolve that dispute if altogether. If and if that mediator doesn't work, the court tries everything in its power to get the matter resolved, so that divorce doesn't happen. Divorce is something that our country as a whole, specific in Hindu law, and it's a we dislike it. Divorce is a taboo. If the divorce is happening, nobody celebrates it. We generally, if we hear that somebody is getting divorced, we are like, oh, this is something wrong that has happened. No, it's not good. People don't celebrate it. People don't look forward to it. You will see people having huge parties for marriage, but nobody is having marriage party or reception for divorce. Divorce is something that is disliked. It's a taboo. Somebody got divorced, people see them with sympathy. Or sometimes how see that person got divorced, so he must not be a very good person. That is also a unfortunate consideration. But so that is why our public policy also reflects this idea. The government says, the parliament said under Family Courts Act that there should be an attempt of reconciliation. Because once a marriage is broken, it does not have very positive effect on the society. Suppose, especially in the cases where children are there. So marriage is broken, the children are adversely affected. That is a universally accepted fact, especially in our legal system and our society. Children who are from broken marriages, they suffer. The dispute between the parents is often reflected on the upbringing of the children. Most and see, the criminologists have said that people who are from functional families are supposed to be better citizens, and a lot of problems come when the people come from broken families. Also, exceptions are there. People from broken families have done exceptionally well, but we call it broken family. When divorce happens, it's very hard on the children. That is why the courts is always in favor of reconciliation. That whatever happens, you adjust kindly. You do not take divorce, do not dissolve the marriage. You give it another chance. You try and forgive. You try and adjust. So the court, they actively try to manage that situation, and that is something that court is mandated by the law to do. मतलब लॉ में लिखा है कि कोर्ट को रिकंसिलिएशन सुलह समझौते का प्रयास करना पड़ेगा. So the courts they focus on this matter of reconciliation. So the first dimension of matrimonial causes is attempts of reconciliation. How the court, apart from dissolving the marriage, also gives decrees with an attempt to bring reconciliation between the parties in. हस्बैंड एंड वाइफ अगर वो झगड़ा कर रहे हैं, तो उनकी मैरिज डिसॉल्व करने की जगह देयर आर अल्टरनेटिव रेमेडीज दैट द कोर्ट गिव, सो दैट द पार्टीज विल अगेन बी टुगेदर. दैट इज समथिंग देयर. अब इफ द मैरिज हैज टू बी डिसॉल्व, देयर आर जनरली थ्री टाइप्स ऑफ वेज इन व्हिच मैरिज कैन बी डिसॉल्व. फर्स्ट इज divorce by fault ground. Now, what is fault ground? So obviously, the in Hindu law, one of the parties cannot unilaterally grant divorce to the other. Like husband cannot go and say, "I wife that I give you divorce, talak." And that happens in Muslim law also. Husband can give divorce to the wife unilaterally. If the husband wants divorce, the divorce will happen. But in Hindu law, that is not the case. A Hindu woman cannot be left by saying divorce, or the husband cannot unilaterally on its own volition cannot give divorce. Same, even the wife cannot leave the husband just like that. So if suppose one of the party wants divorce, so now they will have to go to the court and prove fault ground. They will have to give evidence, adduce evidence, and prove what is wrong with my spouse. And you cannot say I don't like him or like I don't like her. There are specific conduct, specific things that are considered matrimonial wrong, that are considered wrong, and that you will have to prove to the court कि सर हमारे spouse में ये problem है या हमारे spouse ने ये किया है. This is the matrimonial wrong that my spouse has done. Now, if you can prove that and you can simply satisfy the court that one of the grounds exists, the court will grant divorce. Okay, this is called fault ground, in which one party is at fault, some party has done something wrong, and the other party approaches the court and says that, see, I am the victim, this person has done this wrong to me, now I want divorce. So one party has done matrimonial wrong against the other party is the victim, and they are seeking divorce, and the court gives on the basis of fault of one of the parties. This is very important. This is fault ground. Then we have divorce by consent, mutual consent. Now, this you must have heard that if husband and wife they both agree that let's dissolve the marriage, they simply cannot dissolve it on their own. But if they agree and they make a complete settlement and they agree about it, then they can go to the court and say, "Ki, sir, we are not willing to live together. We don't like each other, and we don't want to continue this marriage. So simply grant us divorce, and so the divorce will be granted." Okay, this is divorce by consent. Now there is a procedure to it. We'll discuss it later. So divorce by consent simply means that if the parties they are willing to dissolve the marriage, then they can approach the court and get the marriage dissolved. Then lastly, we have breakdown theory. Breakdown is generally understood in two terms. One is when the attempt of the court to bring reconciliation between the parties fails. Court has tried to reconcile them by following the step in point one, restitution and judicial separation. But if the court fails, in that case, the court considers it at breakdown. That, see, we have tried to reconciliation, but there is no benefit to that. So let's get rid of it. There is nothing left in the marriage. Marriage is essentially dead. So you should not drag a corpse. So essentially, then the divorce is granted. Secondly, the divorce is granted in those cases where the Supreme Court or High Court feels that the marriage is essentially dead. The marriage is essentially over, but there is no fault ground and there is no consent. Sometimes parties they don't like each other, they live separately, but they're also not willing to give each the divorce. They are not willing to give the divorce so as to inflict pain on their spouse. They think that if I'll grant divorce to my spouse, he or she will become happy. They'll get married again. They'll have a good life. So stay married, stay miserable. That is the approach sometimes in a marriage. So in those cases, the High Court or Supreme Court they use their inherent power, special powers, and dissolve those marriages. And that is considered allowed. That is called breakdown. That is something that we have to remember. Okay. Now let's talk about the first dimension. That is the attempt of the court to bring reconciliation between the parties. So there are two decrees. First is restitution of conjugal rights, and second is judicial separation. Now, what is judicial restitution of conjugal rights? Restitution simply means restoring the earlier order. जैसे ये कुछ चीज थी और वो अगर बदल जाए तो उसको वैसा करना जैसा पहले था. That is called restitution. Restitution simply means restore the previous situation. And conjugal right means the right spouse has towards each other. हस्बैंड और वाइफ की शादी हुई है तो उसके कुछ राइट्स हैं अगेंस्ट, लाइक फर्स्ट राइट इज ऑफ कंपनी. The husband and the wife they are supposed to give each other company. Then they are supposed to each other care. There is some degree of dependency between them. then there is an expectation of sexual intimacy, there is a expectation of emotional support, there is expectation of financial support. So they're all considered as conjugal rights. So restriction of conjugal rights simply the meaning of restriction, have you understood? रेस्ट्रिक्शन का मतलब होता है कि आप पहले वाली स्थिति पे ले जाए, रिस्टोरिंग द अर्लियर ऑर्डर. और कॉन्जुगल राइट्स मींस द राइट हस्बैंड एंड वाइफ हैव टुवर्ड्स. अब रेस्टिट्यूशन ऑफ कॉन्जुगल राइट्स का मतलब होता है इफ द कॉन्जुगल राइट्स आर ब्रोकन, द सेंस वन ऑफ द पार्टीज इज नॉट फुलफिलिंग द कॉन्जुगल राइट्स ऑफ अनदर, in that case restitute those conjugal rights. Now what happens in these cases? Suppose one of the spouse has left the other spouse, simply withdrawn himself or herself from the society of another, from the company of other. कोई व्यक्ति अगर अपनी वाइफ को छोड़कर चले गए, कोई महिला अपने हस्बैंड को लोग छोड़कर चली गई, तो in that case that is considered a breach of conjugal right. If I have a wife, I have a right to have company, क्योंकि कंपनी पहला राइट है. Obviously once you have company you will have care, finance and sexual relationship. All those rights flow from company, from association, from physical proximity. So if one of the parties has simply withdrawn from the company of the other spouse, मैं अपने वाइफ को छोड़कर चला गया, मैं अपने हस्बैंड को छोड़कर चली, in that cases, if that leaving the spouse is without consent and excuse, जैसे अगर obviously if I took the consent of my wife कि I want to go somewhere, my wife says go, and then I go, that does not mean that I have left her or I have committed a breach of conjugal right, because I've gone with her consent. Similarly, if I have a legit excuse like I am going for some kind of employment, रोटी कमानी है, सपोज मैं सेना में हूं, मैं पुलिस में हूं, या फिर my job requires me at some place. Suppose I am currently in at one place and suppose my job takes me somewhere else. Obviously, being employed is expected of me. So for work, if I go, for care of my children or care of my parents, I go, I have a legit excuse why I am leaving my spouse. Suppose a woman says that, okay, my father is in a very ill condition, there is no one to take care of him, and they move, and she moves from her husband's place to her father's place where he is ill. Now that will not be considered a breach of conjugal rights because she has legitimate excuse that why she have left the company of her husband. Similarly, husband has a legitimate excuse when he has gone for some work. Wife also, if she is employed and her employment takes her someplace, in that case it will be considered a legitimate excuse. So if there is no excuse and there is no consent of the party, and because of that, and without consent or excuse, one of the parties has withdrawn himself from the company of another, husband goes away from wife, wife goes away from husband, that is breach of conjugal right. Now if the other party, the one who has been left, जिसको छोड़ करके गया चली गई है उसके हस्बैंड या वाइफ, they can approach the court and say कि sir, my spouse has left me, the spouse had no right to leave me, so ask that spouse to come back to me. Then the decree that court issues is called a restitution of conjugal right. Court will ask the other spouse कि भाई आप क्यों छोड़ करके गए हैं, why you have left your spouse, what is your excuse, what is your reason. And if they fail to provide any cogent reason, the court will order them that I order you now to go and live with your spouse. If you have illegally left your spouse, in the sense that there is no reason, there is no legit logic why you have left. There is a logic. Suppose my spouse beats me and then I have left my spouse, then that is a legit reason. I have to go work, that is a legit reason. But without any logical reason, if I have left my spouse, in that case, court will order me to go and live with the spouse. That you are not supposed to leave your spouse, you go and live with him or her. That is something the court will order. That you have to understand. So for restitution, If one of the parties has left the company of their spouse without any excuse, reason, or consent of their spouse, in that case, court can order that spouse that you go and live with your better half. जाइए आप रहिए अपने spouse के. Now, if they don't do it, still it's not a crime. ऐसा नहीं है कि जबरदस्ती the police will arrest them and will throw them in the same room. That is not the case. But nonetheless, civil remedies can be exercised. Court में जाके compensation and all. So the point is, the civil court will ask them to go live together. If even they refuse, there is no criminal action for that. ऐसा नहीं है कि jail भेज देंगे. But nonetheless, the restriction of conjugal rights is a remedy. Then we have something called judicial separation. Now, judicial separation is opposite of restriction of conjugal rights. Now, in judicial separation, suppose one of the parties has approached the court of law for divorce. Now, this is very important. One of the parties to the marriage have come to the court कि sir हमको चाहिए divorce. They have come for divorce. Now the court is satisfied, yes, there is ground for divorce exists, or there is some truth to what the complaining spouse is saying. Spouse complains, ne complain kiya, and the court is convinced that yes, something is wrong. Now, obviously, the allegations that are made are not baseless. But the court also sees that there is a possibility of reconciliation. Means the dispute between the parties have not crossed a certain threshold beyond which the matrimonial relationships become irreparable. So there is some scope, there is still some hope. In that case, the court will ask the parties to live in judicial separation, to live separately. Now, what will happen if they live separately? Now, the old logic goes, na, the absence makes the hurt grow fonder. Sometimes party live together and they understand that there is no love between them. But much of love is about habit. I have seen people bickering in their marriage, but once they stay apart for 10-15 days, they become frustrated. No? They can't live apart. They'll fight constantly once they are if they are together. But if they are apart, they become even more restless because the affection represents itself in many ways. So the court will ask the parties to live separately. No, you will live apart. But once you live apart, then the court's expectation is that by living apart, you will all realize the importance of each other in your life, and there is some kind of reconciliation between the parties. Why it is opposite of judicial restriction of conjugal rights? Because in restriction of conjugal rights, court is asking one party to go live with them, and in judicial separation, again, there also the attempt to reconciliation is there. Here also, the court is asking the parties to live apart, live separately, but the expectation is that eventually they will reconcile and they will be together, and whatever differences between them, if they'll live separately, they'll realize the importance of each other in their life and they will live together. That is called judicial separation. It has very similar grounds for divorce. One of the parties reaches the court for divorce, they may seek judicial separation, or simply they may ask the court for divorce. The court, instead of granting them divorce, can grant them judicial separation if the court is convinced of two facts. Number, court is agreeing that there is some ground for divorce. Yes, some matrimonial wrong has been committed by one of the parties. And two, there is a possibility of reconciliation. Possibility of reconciliation. So the court will ask them कि भाई कल से आप लोग कल 9:30 बजे, सॉरी आई रिमेम्बर्ड अ मी, कल से आप लोग अलग अलग रहिए, एंड if you come together, that's well and good. You come together, then if the parties inform the court that we have reconciled our difference, the court will simply rescind, simply cancel this decree of judicial separation and will allow them to live together again. Or if despite judicial separation, if they don't come together, then that's a ground for breakdown grounds that we'll discuss in the last. Okay? So restriction of conjugal rights में one of the parties has left another party. The party who has been left, परित्यक्त जो व्यक्ति है मैरिज में, he will file a case कि sir, ask my spouse to come back to me. If the court is convinced um, that this person has left without any reason, without any excuse, without any consent, in that case, the court will ask that party who has left the matrimonial home, company of their spouse, to come back. In judicial separation, one of the parties has approached the court, stated that yes, sir, I want to take divorce from my spouse because of this ground. They have proved their reason substantially, but the court thinks that there is a possibility of reconciliation. The court will ask them to live separately. There's no time limit how much time they will live apart, but they can live apart. And if the court is convinced that the parties have actually reconciled, they will take back the decree of separation and allow the parties to be together. But if still there is no reconciliation, parties are living apart and they are also having dispute, in that case the court will can declare that marriage, can grant a decree of divorce. That will come later. Okay, this is about restitution and judicial separation. एक जगह साथ में लेकर ला करके समझौता करने का प्रयास है, एक जगह अलग अलग करके समझौता करने का प्रयास है, बट द होल अटेम्प्ट इज ऑफ रिकंसिलिएशन. नाउ अब समझिए फॉल्ट ग्राउंड्स क्या क्या होते हैं. यानी इफ somebody saying that I am going to take divorce, it's likely that they're talking about fault ground. Section 13, infamous Section 13 of Hindu Marriage Act, which talks about grounds of divorce. If you want to take divorce from your spouse, you will have to fit your grievance in 8 of these grounds that I'm talking about, in these 8 pigeonholes. If you fail to prove these grounds in the court will not grant you divorce. You cannot simply go to the court and say, sir, I don't like my spouse. My spouse is too ugly. My spouse is too talkative. She's not. But you cannot simply say that you are not in love with them. You know? You cannot say that, okay, I am bored or I have fallen out of love. ये सब फालतू बातें. The divorce can happen only in these grounds. First ground is obviously is adultery. Now, what is adultery? Adultery is being unfaithful to your spouse. So a person can go to the court and can adduce evidence that my spouse had sexual intercourse with someone other than me. Yani the party cheated me. If one of the spouse cheats another spouse, that is considered a grave matrimonial wrong, and that's the ground for divorce. Because in a marriage, there is an expectation of exclusivity. If I marry someone, there is a unsaid bond, or there is an understanding that obviously now from now on, I take you as my exclusive sexual partner. And it goes both ways. And it is one of the vows in the marriage that I will be exclusive and faithful towards you. Suppose one of the spouse breaks that promise, enters into sexual relationship with anyone else. In that case, if the spouse proves it in the court, then it will be a ground for divorce. The divorce will be granted. Very important. This is called adultery. Now, adultery may the other party has to actually prove sexual intercourse. They cannot simply say that, okay, my spouse is talking with someone. Means you cannot simply put forward your suspicion. You have to give evidence. Now, evidence, you do not have to give direct evidence, but you have to give solid evidence which raises a very solid presumption that your spouse is cheating with you, has had sexual relationship with someone. Like, I'll give you an example. Simply to understand, suppose if a person goes and says, sir, I saw my husband and wife in a movie theater with someone or at a restaurant with someone. That will not constitute a ground for divorce on the grounds of adultery. Now that my spouse has a best friend of opposite gender. No, this is not ground for adultery. The adultery's ground is when your spouse meets someone with a reasonable expectation of privacy. That if somebody can prove, sir, my husband or wife went to a hotel room without any purpose with someone else, that will give a very solid evidence. आप अगर ये साबित कर पाएं कि your spouse was with another person without any reason, in privately or with a degree of secrecy, and they are trying to hide it, that will constitute adultery. That in that way you can prove it. Obviously, if you have a video or photograph, that makes it very simple. Even without that, you will have to actually prove it in such a way that an ordinary person will presume that there is no explanation for that. Like nobody will go to with a stranger to a hotel room without any context. That is the case, but a person can meet with another person to a coffee shop if they are friends, if they are colleagues, even random strangers can meet at a restaurant. Similarly, movie theater you can go with a friend. Two people of both gender in secrecy they are meeting some. Now that constitutes that resists presumption of adultery. Similarly, you can prove it otherwise by confession, by letter, by text messages in which expressively adultery is confessed or something. That is the case. But it has to be proved. Merely being suspicious, adultery will not be proved. That is something we have to remember. Secondly, the sexual intercourse that we are talking about, cheating that we are talking about, it must be voluntary. If the spouse was sexually assaulted, raped, then in that case you cannot say that the other party has committed adultery. Suppose someone's wife has suffered a sexual assault, he cannot go to the court and say, sir, my wife has been raped, so I want divorce from her. Absolutely. Voluntary sexual relation. If the party committed, cheated on you voluntarily, that case, it is a ground for divorce, else it is. Then again, we have cruelty. Now, cruelty is a very, very, very broad spectrum matrimonial. Cruelty, it's very difficult to define cruelty, but I'll give you basic idea of it. Cruelty is inflicting physical or mental pain on the spouse. Very simple. Physical cruelty, mental cruelty. If you treat your spouse, if your conduct towards your spouse is such that it harms her body, it harms her mind, it harms her state, her well being in the sense that she feels threatened, she has she get the urge to commit suicide, that all those things are covered under cruelty. Physical cruelty is most easy to understand. If you treat your spouse violently, आपने अपने spouse को पीटा, in that case, obviously it is cruelty. No doubt about it. Very simple to understand. If the wife can submit or the husband can submit injury reports or evidence, some witness कि सर हाँ सर हमारे सामने ये व्यक्ति अपनी पत्नी को पीटता था या महिला अपने पति को पीटती थी, if that can be proved, it's cruelty. And physical cruelty is fairly easy to prove. Secondly, mental cruelty. Mental cruelty is something that is tricky. Mental cruelty is inflicting such pain or doing such behavior that an ordinary prudent person will not be expected to live with their spouse. Meaning thereby, my behavior is such that an ordinary woman will not feel safe or it will become problematic, her cannot be reasonably expected to live with the husband. If my husband is such that the conduct of the wife is such, now this can have a wide variety of things. So suppose if the husband is asking for dowry, if the wife is extremely suspicious of the husband, if the husband uh, does not treat her, he does not give her enough freedom, does not let her out of her house, tries to compel her to do work, something like that, that is cruelty. If the wife says to the husband that you fulfill my unreasonable demand, deny sexual intercourse, either party, deny to have children, either party, all of those cases are considered as cruelty. I cannot say to my wife A woman cannot say to her husband that I don't want to have sexual relationship with you. Neither party can say I do not want to have children with you. All those things come under cruelty. You cannot deny whatever is reasonably expected in marriage. If one party fails to take care of another party when they are sick, that's also cruelty. If one party defames another party's disrespect another party in public or private, in public, specifically considered cruelty. Even privately doing extremely violent or extremely unreasonable behavior, that's also cruelty. So cruelty has a very wide domain. It's physical, it's mental, it's financial. If the husband or the wife restricts the other party financially a lot, causing her their pain, in that case it's also cruelty. So the cruelty has a very, very wide connotation. So what constitutes cruelty, what does not constitute cruelty, is depends on the context as well. Contextual, why it's contextual. Because what may be considered cruelty in one circumstance may not be considered cruelty in another. Like I'll give you example. I told you denying sexual community is considered cruelty. So if the couple is 25-year-old, they are both 25 frogs, that case it will be considered a grave cruelty. But what if there are 70? If both are 70, then it will not be considered cruelty, depending on the context. Similarly, suppose somebody is from a very rich, affluent, and educated society. In that case, even some curse words can be considered cruel. But in the society where curse words are generally way of the life, those words will not be considered cruelty because it has to be contextualized. किसी परिस्थिति में वो cruelty है या नहीं? Very important to understand. Secondly, cruelty is a state of things. Means one isolated incident cannot be considered as cruelty. This is very important to understand. Now there is a movie in few years back called Appod, the Bollywood movie feature film that revolved around the context that the husband once in a fit of rage slapped his wife. Now that's a very inappropriate behavior. There might be a criminal case for that. But to my understanding in civil jurisprudence, if that is an isolated incident, एक ही घटना है, so generally the courts are unless that is very severe, मतलब grave चाकू वाकू मार दिया तो obviously that will be there. But if it is not extremely severe, one isolated incident cannot be considered as cruelty. Cruelty is always a state of things, regular or repetitive behavior होना चाहिए. If I have said some inappropriate things to my wife once, है ना, in that case it may not constitute cruelty if I am otherwise very affectionate husband. That is something that you have to consider in. Okay, if I am a wife and I am generally very, my husband is generally, um, I behave very generally very correct, but once I throw balloon towards my husband, in that case, if that happened once, it will not be considered cruelty. Because cruelty has to be a state of things. So it has to be contextualized and it has to be a state of things. These two things you must remember. So cruelty is very subjective, but you have to prove to the court that the extent and nature or behavior is such that I cannot be reasonably be expected to live with my spouse. So grant me. Courts grant divorce. Generally, this is the most common ground you will see a lot of complaints on that basis. So whatever inflicts physical or mental pain on the spouse is considered cruelty. Okay, and it need not be intentional. You are doing something and you do not intend to be cruel towards your spouse, but you might be cruel. It might be cruel. Like there was a case in which a woman administered some drugs to her husband. Uh, it was an aphrodisiac to enhance husband's sexual prowess, love potion kind of thing, and it threatened husband's life. Obviously, you cannot give pharmaceutical drugs without a proper prescription, without doctor's consultation. So even if she thought that what she is doing is to have a better life or better sexual have life with her husband, ultimately it threatened the husband's life. So her intent was not to be cruel, but her behavior was nonetheless cruel. तो क्रूवल होने का इंटेंट होना जरूरी नहीं है. क्रूअल होना जरूरी है. Okay, that is how it works. Okay, do you think? See, there is a few years back there was a movie called Mrs. Lot of debate on social media over that. Lot of debate in which there is a woman who was forced to work, and everybody considers her a cook and a cleaner. And so, do you believe those people who were subjecting her to that cruelty, whether they were doing it consciously? I'll say the answer is no, because they are accustomed, their upbringing is such that they have considered women to do those things regularly. जो व्यक्ति किसी व्यक्ति ने अपने माँ को जो करते देखा, वही वो अपनी वाइफ से एक्सपेक्ट करते हैं. तो a person might love his wife a lot, but they might say कि no, नहीं, that चटनी सिलबट्टे की होनी चाहिए and all those things. That becomes problematic, right? So intent to be cruel is not necessary. One can say कि see, I take care of my wife, whatever I shopping ले जाता हूँ and gold jewelry दिलाई and all. But I compel her to do all the household work even if she is not willing, because that's the custom of my family. So my intent was not to be cruel, but nonetheless the behavior is cruel. When you compel her to do something uh, against her wishes, that is cruel. The cruelty need not be intentional. So if you are cruel, if your behavior is such that is inflicting mental and physical pain on your spouse, so it will not matter if it is intentional or not. Okay. Third is desertion. Desertion is very simple to understand. If you have left your spouse, if you have simply left your spouse for a substantive period of time, if you have left your spouse for 2 years, 3 years, okay. So if you have left your spouse, and that too without excuse, we just discussed the restriction of conjugal rights. This is very similar ground. This is very similar ground that a party has left the spouse. And if you have left the spouse without any reason, without their consent, in that case, it is called desertion. Desertion, generally, this word is used in context of army. कि आप अपनी ड्यूटी छोड़ करके भाग गए, if you leave your post, that is considered as desertion. But in matrimonial relationship as well, if you fail to perform your matrimonial relationship and you have simply left your spouse and have simply withdrawn yourself from her company for 2 years, minimum 2 years, if you have left your spouse, that constitute desertion. अगर मेरा स्पाउस मुझे छोड़कर चला गया है और 2 साल से चला गया है, तो इन दैट केस इट विल बी कंसिडर्ड desertion. नाउ desertion किस बारे में क्या क्या बातें ध्यान में रखनी? फर्स्ट, desertion has to be intentional, meaning if my spouse has actually left me trying to end our relationship, simply has left me for good, in that case it will be considered desertion. But if my spouse has not left me, actually they have gone to a different country to work, or there is some justification to that, that will not constitute desertion. So desertion has to be de facto and de jure, and there must be actual desertion and there must be intention desert as well. If my wife alleges that I have left her, she must prove that I have intention to desert her. If I am stuck in a situation where I cannot come back to my wife, that is not desertion as the case. Secondly, bachon, second thing is desertion is not essentially physically withdrawing or physically going someplace. If you become completely indifferent towards the existence of your spouse, आप उससे बात करना, उससे कनेक्ट करना छोड़ देते हैं. If you simply do not acknowledge the existence of your spouse, in that case you are guilty of desertion. Even if you are living under the same roof, even if you are living under the same roof and you have completely cut off connection from your spouse, that is also called desertion. Desertion is withdrawal from the state of things. I am living with my wife, I am living with my husband, and suddenly I completely break connections with him or her without any reason, without any excuse. And I have simply done that even while living together. That happens. People keep pretense of being married while they have essentially completely they are indifferent towards each other's existence. They are not in each other's company. They are living like two people living in different rooms in a hotel. एक होटल में बिल्कुल बगल-बगल वाला कमरा होता है, मुझे नहीं पता बगल वाले कमरे में कौन है, बगल वाले कमरे को नहीं पता कि मैं कौन हूँ. If I die, he will not be affected. If I am ill, he will not be affected. Similarly, if something happens to him, I will not be affected. So you cannot be like roommates or you cannot be like two people in a hotel room. You have to be as a husband and wife. So one of the spouses completely cuts off relationship, that constitutes desertion. Okay. So the desertion must be there, and desertion must, when the petition for divorce is filed, desertion must continue from that point of time. 2 साल तब तक पूरे हो जाने चाहिए और डिजर्शन तब तक कंटिन्यू हो रहा हो. ऐसा नहीं कि डिजर्शन था बट बिफोर द पिटिशन इज फाइल्ड द अदर पार्टी केम कि सर आई वुड जस्ट वांट टू बी अगेन टुगेदर अगेन, लिव टुगेदर अगेन. नाउ डिजर्शन एंड्स. The moment one of the parties, the party who is in desertion, attempts to reconcile, the desertion ends. Okay. Fourth, conversion. If one of the parties ceases to be a Hindu, converts to a non-Hindu, non-Indic faith, in that case, it will be considered as a ground for divorce. Meaning, if a person who is a Hindu after marriage converts to a non-Indic faith, in the sense he converts to Christianity, Islam, Judaism, or Zoroastrianism. Now, Zoroastrianism and Judaism do not allow conversion or do not encourage conversion. So, essentially, if a person becomes a Muslim or a Christian, now that is a solid ground for the other party to simply go to the court and get the decree of. One can argue that if you are not faithful towards your culture, your God, your identity, how you will be faithful to me? That is one argument. But again, conversion is the personal choice. Law cannot prohibit somebody from converting to another faith, but it can give divorce to the spouse. Now, obviously, the divorce has to be filed in the court and be granted by the court. There is no automatic divorce on conversion. If somebody's spouse converts, that does not mean that the marriage is automatically dissolved. Now, there is that celebrated case Sarla Mudgal. I have also discussed Sarla Mudgal versus Union of India, in which a Hindu man having a Hindu wife, he converted to Islam so that he can marry another woman. Sarla Mudgal filed a case. The question was whether the marriage subsists. The answer is yes. The marriage does not end automatically on conversion. Conversion से marriage अपने आप खत्म नहीं होती. The party will have to go to the court, file a case कि sir, my spouse has converted and is no longer a Hindu. Acha, now if the party becomes atheist, it's not a ground for divorce and renounces his religion, no problem. If he is a Vedic Hindu, becomes a Sikh. He is a Vedic Hindu, becomes a Buddhist. If he is a Buddhist, becomes Jain. Jain becomes Sikh. Any of one of them become Vedic. Absolutely immaterial. Till you are in the fold of the faiths of Indian origin, the faiths that come within the domain of Hindu law, it's not considered conversion. If they become Sikh, no problem. They become Jain, no problem. They become Buddhist, no problem. But if they convert, they leave Hinduism, they go beyond the fold of Hindu law. In that case, that is a ground for divorce, and the divorce is granted very quickly. The conversion is proved the first day, no judicial separation, nothing, no attempts to reconcile. Straight away, divorce is granted. It's a very solid ground for divorce. Okay, moving on. Fifth is unsoundness of mind. This is very important. Unsoundness of mind means the other spouse is suffering from such mental infirmity, such kind of disease, the nature यहाँ पे ध्यान रखिएगा, nature and extent of such mental injury, mental insanity should be that the party who is the other party, the party who is filing the case, cannot be expected to live with him or her, makes them violent or completely irresponsible. This is very important. If my spouse is having such mental disease, such mental infirmity that makes them either violent, completely irresponsible, or unmanageable, or the nature or extent बहुत मैटर करता है बच्चों. The extent of their mental illness is such that I cannot be expected to live with them. Now that's a ground of divorce. I'll give you 4 5 examples. First example is, suppose my spouse is suffering from short term memory loss. In 15, 20, 30 minutes, their memory resets. That case obviously goes without saying that I cannot be expected to live with my spouse. You cannot be expected to live with your spouse because they will simply lose who you are. If they Secondly, if they face some mental ailment like split personality disorder. Right now they are your wife. Now 10 minutes wife, they are become someone else. If they are right now something else and becomes your husband, becomes something else. Now this is problematic. Similarly, if they suffer from schizophrenia, whenever they have the episode or seizure, they become violent, become extremely irresponsible. That is also hugely problematic. But there are some mental elements which are easily manageable, like people having phobias. Some people might be quick to anger. Some people might have OCD. All of these things. See, if we'll uh, actually do a very close analysis, we all have some or the other kind of mental disease. If you have, you all must have some kind of phobias, some OCD behavior, some kind of quirks you might have. So if you have a quirk or there is some OCD or there is some phobia, that is not considered to be a mental element of nature that will make a person unfit for marriage. They're neither violent nor irresponsible nor extremely weak at intelligence. That's not a problem. Every people have their quirks. Some people are very direct. Some people are manipulative. See, every person is built in a different. In order to get this degree of divorce on the ground of unsoundness, you will have to prove to the court how they're unfit for marriage completely. How you cannot be expected to live with them because of their nature of the mental ailment they have. There are very serious mental ailments, makes the person violent, suicidal, and the extent of it is there. If somebody has some problem which is very mild, easily manageable with medicine, that will not constitute a ground of divorce. Okay. Then we have venereal disease in communicable form, sexually transmitted disease, STD. If my spouse has STD, if your spouse has STD, obviously you have a right to get a decree of divorce because I say it's given. Sexual expectation, sexual relationship is a essence core of marriage. So if a person's spouse is having communicable sexually transmitted disease, in that case, the solid ground for divorce. Syphilis है, gonorrhea है, herpes है, AIDS है, all those things, if are there, that is ground for divorce. But it must be sexually transmitted disease which are primarily transmitted through sexual contact. From sexual contact, a lot of disease can be transmitted. Like suppose if you have COVID, if you have relationship with someone, sexual relationship with someone, they'll also get COVID. But COVID is not a sexually transmitted disease. It is not generally communicable through sexual contact. If you simply come close to someone, if you hug someone, it can affect. Common cough and cold, that can also happen. A number of diseases are there which are simply by contact it can spread. But there are diseases like somebody is having syphilis or AIDS. It cannot spread by mere contact. Generally, it is spread through sexual contact. So, venereal disease in a communicable form is a ground for divorce. Okay. Then entering into a religious order, becoming sannyasi, renunciation of the world. Now, the essential term is renunciation of the world. if a person simply enters into a religious order is such which in which religious order there is a custom or there is a parampara of leaving all the worldly affairs, like a person takes sannyas. If a person simply takes sannyas by entering into a religious order of ascetics or monks, becomes a yati, a woman becomes a brahmacharini. In that case, it's a ground for divorce. Because in Hindu law, obviously the person who is taking sannyas is has a lot of reverence. You cannot stop someone from taking sannyas. But once they take sannyas, now they will simply say who you to their wife or husband that who are you? I don't. All material ties are cut when a person takes sannyas. Sannyasis perform their own shraddha so that they are considered dead for all intent and purposes. And when you take a sannyas, it will be like a rebirth. The earlier person they change their name, shave their heads, or do not shave their heads depending on the sampradaya that they have. Do not take their father's name. Instead, take their guru's name whenever relevant. They do not associate themselves in any way with their former life. So once a person becomes a sannyasi or yati, enters into religious order and renounces the worldly affairs. In that case, their spouse has a right to approach the court of law and get a decree of divorce. Okay. Now the eighth point and final ground is presumed death. Now Indian law says that if a person has not been heard alive for 7 years by the people who would have heard from him if he were alive, like his family members, friends, employer, or whatever. In that case, they are considered presumed dead. So, if a person's spouse, husband, or wife is unheard or they are not known to be alive for 7 continuous years, and you can go to the court and prove that sir, my spouse is missing and they're missing for 7 years, on that basis, a decree of divorce can be granted. But you can the marriage is not automatically dissolved. ना आपने मान लिया your spouse is dead without any death certificate being issued by the governmental authority, or um, without a lapse of 7 years, if you presume your spouse is dead and you enter into a marriage again, then you have committed bigamy. Because if they were not found for 7 years, you should have approached the court of law and get a decree of divorce. Getting a decree of divorce is mandatory. Only if they are certified as dead, then they are dead. If they are not certified as dead, in that case, if they come back after 10 years, 15 years, 20 years, and you have not taken divorce from the court, then you are still married. If you have married someone in the meantime, that marriage will become invalid. This is very important to understand. So, this is a ground for divorce. The marriage does not automatically dissolve if the person goes missing for 7 years. You can go to the court, prove to the court that sir, my spouse is missing for 7 years. Now grant me divorce. The court will grant you divorce. But that is when you will approach the court of law for that. You will say to the court, sir, please grant me divorce. Then the divorce will be granted. Very important distinction. You not simply say, yes, my spouse is missing. Spouse will come back. He came back for Tulsi. This joke will not be understood by you. It is for older people. Okay, so presumed death. So presumed death simply means that the party is not heard alive for 7 years by the people who would have heard from him if he were alive. Then the party is presumed to be dead. On this presumption, the marriage can be dissolved. It is not automatically dissolved, but can be dissolved by a court. So these are fault grounds. If you want to take divorce from your spouse and your spouse not has agreed with it, then you will have to prove these 8 grounds, one of these 8 grounds, to the court of law to get divorce. It's difficult. That's why we have divorce by mutual consent. If both the parties agree that let's dissolve our marriage, they can approach the court of law, file a case. 13B section is there. Now, there are some conditions to that. Number one, if you are approaching the court of law for divorce by mutual consent, 1 year must have been elapsed your marriage. कम से कम आपकी शादी को 1 साल हो गया होना चाहिए और 1 साल से कम आप अलग रह रहे हो. You must be living separately for 1 year before you can approach the court for decree by mutual consent. Your marriage must be 1 year old, obviously goes without saying, and there must be 1 year of separation. You are filing a case for mutual divorce by mutual consent. If the parties are living together and the next day they file for divorce by mutual consent, it's not allowed. The only way it will be allowed is if they have living separately for 1 year. So the court will understand it's not a hasty decision. ऐसा अचानक रात में झगड़ा हुआ सवेरे डिवोर्स लेने नहीं आ गए. 1 साल से कम अलग रह रहे हो. That is the precondition for filing a divorce by mutual consent. Now, what's the procedure? Now, both the parties will have to file a common application to the court. Together, they will have to file a case and they will have to convince the court of some fact. Now, first fact is that they're eligible in the sense that they have been living separately for 1 year and they must swear in that petition that we have irreconcilable difference, we cannot live together, we want divorce. And in that case, they will file this application. They'll also have to prove to the court, ki, sir, we have uh, resolved all our other disputes. Like if they have children, so who will have custody of that children? How much alimony or maintenance has to be given? All those disputes, if they have joint property, what will happen to that property? So they will have to convince the court that all of their disputes have been resolved. Only when they will prove that all the disputes have been resolved, then the court will start what we call cooling period. The court will say, okay, you have filed this petition, very good, first motion done. Now you come back after 6 months. Now this 6 months is called cooling period. This is mandatory. The court will ask them to observe a cooling period that yes, you have come together, you have come for mutual consent. Now you come back after 6 months. Minimum 6 months you come back, you think it through. This is called cooling period, so that even if your dispute is there and you have filed a divorce petition, but still if at all you must think about the enormity of the decision that you are trying to take, कि भाई अब खत्म ही हो जाए marriage हमारी. So cool off. So this cooling period is there, 6 months. After this cooling period, after 6 months, but before 18 months, there's a 12 months period in which you must approach the court of law with a second motion, second application that yes, sir, 6 months are completed. Still, there is no reconciliation. We still want divorce. The court will grant you. No problem. But in this period, if the parties, one of the parties also withdraws the consent, no, I don't want divorce. In that case, divorce will not be granted. Then this 6 months period is very important, generally granted. But the High Court or Supreme Court, even the lower court, if they think that there is no point of delaying this particular matter, the marriage is essentially broken. Generally, there is a very prolonged period of separation. 10 साल हो गए separation में रहते रहते. If they are coming together for divorce, the court can waive this cooling period. Waive मतलब क्या कि कोई बात नहीं, जिस 6 महीने के पीरियड के बाद आपको डिवोर्स देते नहीं, अभी देते. Because we are convinced that delaying the divorce by 6 months will only increase the misery of the party. The parties will be more miserable if we ask them to wait for 6 months. So the divorce is granted immediately. The court, if you can convince the court कि sir हमारा there is absolutely no chance of reconciliation, there is no point of making us wait for 6 months, give us divorce, the court will grant you. That is something very important. This is called divorce by mutual consent. Now, one of the parties they want to withdraw consent at any point of time, it can be withdrawn. So the divorce file करने से divorce grant होने तक, both the parties should consent to divorce. One of the parties says, no, I don't want divorce. The divorce will not be granted by the court. Okay? Now this is called breakdown theory. Now this is not a separate ground for divorce, but we simply understand that in cases in which the marriage is essentially broken, there is no attempt of reconciliation. In those cases, court grant divorce. Firstly, we discussed that there are two attempts, two methods in which the court tries reconciliation. One is restitution of conjugal rights, another is judicial separation. So it says, the law says, Hindu Marriage Act says, that if after granting judicial separation or asking the parties to be together by uh, issuing a decree of restitution of conjugal rights, if there is still no resumption of cohabitation, if the parties are still not together, in that case, if one of the parties comes to the court and say, Ki, sir, you tried reconciliation, but obviously there is no benefit to that. In that case, court can grant divorce on this basis. We have tried to bring reconciliation between them by restriction of conjugal rights or by judicial separation, and 1 year has elapsed, but absolutely there is no resumption of cohabitation. Parties are still living separately. They have not come to the court for the purpose of reconciliation, and one of the parties says, Ki, sir, I want divorce, then the court will grant divorce simply on this basis कि हमारे प्रयास के बावजूद रिकंसिलिएशन नहीं हुआ. This is called breakdown. ठीक है. So if the breakdown happened, there is non-resumption of cohabitation. In that case, divorce can be granted. Now the Supreme Court also has been known to use inherent power in some cases. Under Article 142, Supreme Court is known to grant divorce in some cases in which the court thinks that the parties is suppose both the parties are at fault. दोनों ही पार्टीज आपस में झगड़ा करती हैं. बोथ आर क्रूअल टुवर्ड्स ईच अदर. So when both are at fault, neither can get divorce, क्योंकि वही है rule, come with clean hands. So if both are at fault, suppose both of them cheated on each other, both committed adultery. Now neither party is a victim. Neither party can come to the court. So the divorce case will be dragged on. No party will get any benefit from that. So if the court believes that the marriage is essentially dead, there is absolutely no possibility of reconciliation, and the parties are dragging that marriage, one of the parties is dragging that marriage with the sole purpose of torturing or inflicting pain on their spouse, कि divorce तो नहीं देंगे, वरना he will get married again and they will be happy, and I want to make my spouse miserable. That's why I'll not grant divorce, or I'll not agree for a divorce. In those cases, Supreme Court in some of the cases have been known to grant divorce. सुप्रीम कोर्ट उसमें डिवोर्स ग्रांट कर देती है, कहते हैं भाई जाओ, there's no point in this marriage, so it is only prolonged misery. That case, the Supreme Court uses its inherent power and grants divorce. But again, this is a power of Supreme Court. The High Court or the trial court, they do not have this power to simply grant divorce if none of the grounds are there. ठीक है. But ये जो ऊपर वाला ग्राउंड है कि भाई 1 year has elapsed after a decree of restitution or separation and no reconciliation has been there, and one of the party approaches the court for divorce, the court will grant divorce on this. This can be granted by the trial court, family court itself. But inherent power can only be used by the Supreme. So this much is clear. So this much we have discussed. This gives you a brief idea about how the divorce in Hindu law works. Thank you for being patient listeners. In the next class, we'll discuss divorce under Muslim law, triple talaq and everything. Thank you so much for joining me today in your lecture. Thank you so much. Have a very nice day ahead.